tuned in to the Andrew Lawton Show.
Tamara Lich, who is the lead Convoy fundraiser. She was the one that started the GoFundMe. She was the one that was in Ottawa, was yelling out, "Hold the line," as she was arrested by police. Tamara Lich, after a bail hearing yesterday, has been kept behind bars for at least another 5 more days. So that'll bring us to Monday, when the judge will decide whether or not she should be released on bail. That will be about 2.5 weeks, or if I'm being precise here, 2 weeks and 3 days since she was first arrested for organizing a protest. She was arrested on the charge of counseling mischief. I've never heard of someone being kept behind bars with the Crown so fervently trying to keep them there, as is happening in the case of Tamara Lich. I want to talk about this and much more about the aftermath of the convoy with criminal lawyer David Anber, who, believe it or not, is not a Simpsons character. On Twitter, you may be mistaken if you thought that, but he has a real-life identity, and he is sharing it with us today. David, good to talk to you. Thanks very much for coming on the program.
Thanks for having me, Andrew.
You and I talked in a Twitter space a couple of weeks back, and I said I wanted to delve into some of these issues with you further. And of course, this issue has changed. But let me just start with the bail question here. When Tamara Lich was first asking for bail, I think it was the day after she was arrested. Actually, yeah, it's 2 weeks ago today, because I recall the day after was a Friday. And I thought it was bizarre that the judge didn't make the decision right away. And this judge as well, taking 5 days to review the bail. Is this normal in a criminal proceeding?
To a certain extent, Andrew, it is normal. When judges have decisions that are important, I mean, they're all important, but when they're in the national scrutiny and the national eye, if they deal with something that's a complicated legal question, and I appreciate that there are many who feel that this is a slam dunk. It's a mischief charge, and she should be released. And look, I'm a big believer that the first judge got it wrong. But I did also believe at the time that it's a much closer call than people think it is when you apply the rules that apply to bail. And look, the prosecutor who's been arguing the case has been doing a very good job at advancing the prosecution's theory of the case. So Justice Bourgeois wanted to wait until, I think it was after the holiday Monday, the Tuesdays, when she released her decision. So that's somewhat normal. What happened yesterday, and it was what's called a bail review, which is essentially like an appeal. I won't bog down in the minutia of what it is. It's basically an appeal of the first bail ruling to a higher court judge. It's actually, just for those of you who are interested, it's a Harper appointee judge. The provincial court judge was appointed by the provincial government, but this is a superior court judge, a former defense lawyer, a very good judge, very open-minded judge, not a pushover one way or the other. So he heard a full day hearing. Basically, the matter went to close to 6 o'clock in the afternoon, in the evening, and he indicated that he needed some time to reflect on that. Now, I think due to scheduling reasons, he's in other courts and other jurisdictions for the remainder of the week, the Thursday and the Friday. And so the first opportunity after that he would have to render a decision would be on the next Monday. So certainly nobody likes the idea that you have to wait for justice, especially when you're in custody. But I think that there's nothing nefarious going on behind the scenes. That's just the way everything shook out with the way the bail went all day yesterday.
Not being a lawyer, I typically look at the two considerations that seem to come up in any bail stories I've covered as being the seriousness of the offense or the alleged offense, and also whether the person is a flight risk. Now, I'm hoping you can explain what the factors are that go into these decisions, but on those 2 points, we're talking about relatively minor charges here. And also, we're talking about a woman who has had her bank accounts frozen previously, doesn't have a lot of money, and isn't vaccinated, so couldn't, even if she wanted to, get on a plane to flee the country here. So I don't think we're talking about much of a flight risk here. What are the factors at play here that have been justifying keeping her detained, not giving her bail, especially when one of her co-organizers, Chris Barber, was given bail by that first judge, Justice Bourgeois?
Okay, so Andrew, there are 3 considerations in bail. The first, as you indicated, is the flight risk. The second is the substantial likelihood of the repetition of the offense or further offenses. And the third is the reputation of the administration of justice as that's perceived in the community. And that normally doesn't play much of a factor into a typical mischief charge, but it actually is playing a large factor here because it's got such a high profile, because members of the community allegedly were so much affected by what was being framed as a blockade, as an occupation. So on the first consideration, Justice Bourgeois did not detain Tamara Lich on the first consideration. The first consideration, I believe the Crown had argued it was a factor, but that's not been the consideration. It's been the second and the third that have been in play in this particular case. And a lot has been said and a lot has been made of Tamara Lich saying the hold the line. I mean, and again, look, I put myself in the shoes of the prosecutor. If I were prosecuting this, I would be making the same point as he did. It's that the politicians said to go home, the police said to go home, the Emergency Act was invoked, and then as she's being arrested, she says, hold the line one more time. And so the argument that they're making is that she can't be governed by the rule of law. Now, again, I believe that the bail judge got it wrong in the first instance. There's a heavy onus in terms of releasing people, particularly those without a prior record. And so notwithstanding the fact that that's a concern, the conditions of bail could be fashioned in such a way as to alleviate that. Now, in Canada, we don't rely so much on cash bail, although that would have been an option. I know in Quebec, they're a little more interested in doing that than they are in Ontario. Ontario places a big emphasis on sureties. That's a person who is willing to step up and sign for the person and be responsible for the person, like their jailer. So they would turn them into police if they weren't following the conditions. Tamara Lich's first surety was not seen as being suitable, but a different surety testified. There was a publication ban on the identity of that surety, so I can't really say much more other than there was a different surety that was put forward, and there was a debate held over whether or not that person would be appropriate. But moving now to the third consideration, sort of the public's perception of the administration of justice, should this person be released? And we're seeing something that we see pretty much in other areas of civil society or politics or what have you. It's that there are these two different realities of what was going on in Ottawa that are being put forward. There's the reality, at least the one that I saw, and I drove the streets. My offices, you can see right.
Yeah, you had quite a beautiful view of the action and even normally of downtown Ottawa there. I'm actually quite jealous here being in my little basement office of your view.
Absolutely. We're right downtown, and yeah, there was a little bit of additional delays when getting to work, but I could drive, other than Wellington, I could drive pretty much every street downtown. There was at least one lane of traffic opened on every major downtown core street. Say what you will about the flags that were there on the first day, one or two flags that were really, really focused on by the media, but, there were hundreds or thousands of Canadian flags every day. It was a very peaceful and a very cordial protest for a very long time. That's one reality. The other reality is that this was a blockade, an occupation, that there was harassment going on. That we heard, a member of parliament even say that there was sexual assaults that were taking place when there's really no evidence to support that. There was the ongoing honking, which was a concern, and there was a court order that addressed that. But when you get the prosecution that puts essentially a package of photos and pieces of evidence together, including statements from the civil lawsuit that's going on, you get this one reality that makes it look like it's some kind of hellscape, that Tamara Lich was responsible for visiting upon the city of Ottawa. And so I think that to a certain degree, that was the perception that was guiding the first bail judge. And Justice Johnston, he normally sits in Ottawa. He's a little bit removed from the city of Ottawa and was able to, I think, not necessarily tune into what the innuendo is in the media, but focus on what the evidence was before him and put it into the proper context and into the proper prioritization. Because again, people can be released on any crime in Canada, no matter how heinous. So it's a consideration of all three of those factors. I think that the lawyer for Tamara Lich did a good job of advancing the argument on a bail review and getting through some of those technicalities, because it's not quite an appeal. There's some, certain issues that are assumed to have been correct by the bail judge. Other issues can be challenged. There's this concept of a change of circumstances. One change of circumstance that I didn't really see argued that much, which I was quite surprised, is that the protest isn't there anymore.
Yeah, the convoy, the mischief ceases to exist.
Right, exactly. And I know there's always the argument that it could come back, but I think that the landscape is very different right now. Had the occupation, as they call it, been still there and Tamara Lich was released, more of an argument could have been made that, she could give moral support or do something to hinder the police in clearing out the area. But the area is cleared out. It's gone, right? So that's one change of circumstance from the time the bail hearing was first argued that I would argue makes it such that it's even less of a risk of her reoffending and less of a concern to the public overall.
I want to talk about some of the broader aftermath aspects of this. I know you're representing the woman who was trampled by the police, the mounted police in that famous video now. And again, I'm talking about this as someone who was pepper sprayed at the protest while doing my job as a journalist. There's another journalist, a photographer with an agency I can't recall the name of immediately, who was arrested, zip-tied, thrown to the ground by police, and he was later released. There have been a number of incidents like this that have come up. The only force, the only violence, in fact, I've heard of from anyone came from law enforcement on that weekend when this was all basically dismantled by police. So just either generally or on behalf of your client specifically here, what is the recourse available to people for this, even with the Emergencies Act having been in effect at that time?
Well, the recourse available, you have more recourse if you've been charged with an offense. If you've been charged with an offense, you can apply to the court for remedy under the charter. Your charges can be thrown out. The court can make determinations and speak about the police's conduct. The lack of recourse is what often exists when a person isn't charged. We saw people as even far back as the gas can seizures that took place earlier on in the protest, where people were arrested, their property seized, and then they were released hours later. So for those people, I know, for example, the lady who was trampled by the horse, Candice Serro, she's being represented by Matthew Wolfson in my office, and she wasn't charged with anything, but she is going to be through the assistance of Matt Wolfson bringing a professional standards complaint. So that's a chance for the police to be formally disciplined for their conduct. We're going to be doing the same thing for the lady Doreen that you may have seen, who was video recording on her phone a police officer who walks up to her. He walks up to her and says, "Why are you pointing that in my face? Stop recording." And they start grilling her about where she's from. And then they start basically threatening her, "Leave now or we're going to place you under arrest." And I've said this before, but it bears repeating. It's that the Emergency Act did give the police additional powers, but it didn't give the police unlimited powers. And that's how the police were conducting themselves that weekend, where basically whatever the individual officer or the police force as a whole determined was necessary to do, you needed to do or face being arrested and charged with the same thing as Tamara Lich or anybody else who was there continuing to protest.
Yeah, and one of the more concerning aspects was this reverse onus that police claimed. You needed to prove that you had a lawful purpose, not just to be in front of Parliament Hill, but even as that video you just indicated, which we played on the show last week, shows, to just walk down the street 3 or 4 blocks from Parliament Hill. You had to prove to police that you had a reason. And as I understand it, and please correct me if I'm wrong here, it happens often, but detention has a very broad meaning. It isn't just about having handcuffs thrown on you. If police are stopping you and questioning you, that is detainment, is it not?
It is. I mean, there's psychological detention. Not every interaction between the police and the public is a detention, but certainly where the police is taking some degree of control over you and basically threatening you to say, do as I say, or we're going to place you under arrest. I would make the argument that the police are detaining a person, and that triggers...
and for all the Emergencies Act's faults, and there are many, it didn't say you weren't allowed to film a public street.
No, and Trudeau even said when announcing the Emergency Act, he said, this is what it's not. And he said it is not a restriction of the Charter of Rights and Freedom. And you go into the Emergency Act, where they set out the so-called red zone, where they can secure an area. That area, the southern area of that area specified in the Emergency Act, is Wellington Street. The Ottawa Police decided that they were going to have an expanded red zone, and they treated the rest of that area, which wasn't specified in the Emergencies Act, as their full discretion to determine it to be a red zone and treat people however they saw fit to treat them.
Well, I'm glad you're on this, and you've been doing a great job on Twitter, and you have your Twitter handle up on the screen there, David Anber, at demystifying a lot of this for the lay people out there like myself. So I appreciate it very much, David Anber, lawyer in Toronto. Thank you, sir.
Ottawa, thanks for having me, Andrew.
Sorry, I knew Ottawa. We were talking about you being in Ottawa. I'm from London, so they're all just like big cities that go into an amorphous blob to me. But yes, Ottawa lawyer David Anber. Thank you, sir.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.